has been submitted. Now I'll go on
This
to
call is
explain.
now being recorded.
Now I'll go on to explain the perks in the internship, which is a certificate of completion for internship will be given to everyone who has successfully completed the task. For those who have left it incomplete and have not have left the internship in between, no certificate will be granted to you. A cash prize of rupees 500 with a certificate of best RTI drafter will be given. 2 selected interns will also be offered a coupon of rupees 1,000 each by Memo Pandit, and you can use that to purchase any course offered by Memo Pandit. A paralegal RTI position will also be offered to the volunteer. The volunteer will also get volunteership free of cost in our organization. Selected articles of the interns will also be published in a journal with an ISSN number. And this is only for those who opt to write an article. Now, what are the perks of you joining Law Bloom as a volunteer? 1, you will get special discounts on publication in Hoot Welfare Society. You'll have maximum learning and flexible work times for working in Law Bloom. You'll also be able to participate in exciting events and internships, and you will also be given a paralegal opportunity. Interns, please note that whatever queries you have will be taken at the end of the session. Until then, please refrain from sending any messages on the group. With this, I will hand over the platform to Sir Amitra Sir, who will explain a little more on the given internship. Over to you, sir.
Yes, very good afternoon to all you. Actually, I am a little bit down because I am suffering from cold. So first of all, I would like to say sorry for that. So, should I start or anybody else is there to speak?
No, sir, you can start.
Okay. Okay. So first of all, is it possible so that it is possible that the interns introduce make an introduction to me first?
You want each of the
Introduction can
interns
happen.
to introduce themselves, sir?
Yes, just 1 line or 2 lines.
Yeah.
But if you think it is not going to disturb the session, then only. Otherwise, I can start. Okay.
I think that can happen, sir. Interns, can you just unmute yourself and give a 1-line introduction of yourself?
Means you just introduce with your name. Just a minute, with your name and in which law school you are studying and in which year. Okay.
Good afternoon, sir. I'm Avni Jajot. May I continue?
Himali, you take the name.
Yes. Guys, I will take your names and then you can come forward. I'm sorry for the inconvenience caused.
Yeah, go ahead.
1 second. Achintya, can you introduce yourself? Do we have Achintya with us? Okay, Aditi Sharma, can you introduce yourself?
Yeah, good evening. I'm Aditi Sharma. Actually, I'm from Bishop Cotton's Women's Christian Law College. I'm doing my 3 years LLB course. Is that it? Or I need to introduce more?
Okay. Well, sufficient.
Thank you, sir.
Okay. Atulya Chauhan. Do we have Atulya Chauhan with us? Okay. Avni Jajot.
Good afternoon, sir. I am Avni Jajot. I'm from Maharashtra National University, Aurangabad. I am a 3rd-year student.
Okay, great. Thank you.
Okay. Bilal Khan. Do we have Bilal Khan with us? Okay. Garima Dikshit.
Good afternoon, sir. I am a student of 5th year in Army Institute of Law, Mohali.
Okay. That's a renowned institute.
Okay. Thank you. Gaurav Singh. Do we have Gaurav Singh with us?
Good evening, sir. Hello.
Yes.
Good evening, sir. Myself Gautam Singh. I am student at Law Faculty VHU, third year student.
Great.
Okay, thank you. Gunjan Khetan. Do we have Gunjan Khetan with us?
Yes. Good afternoon, sir. Myself Gunjan Khetan, and I am BBA LLB third year student from Modi University.
Okay. Gujarat. Yes.
Yeah. Thank you, Gunjan. Do we have Gurneet Singh with us? Gurneet Singh? All right. Harsh Karote?
Good afternoon, sir. This is Harsh Karote from ILS Law College, third year.
Okay. Thank you.
Thank you. Harshita Gupta?
Good afternoon, sir. Harshita Gupta this side. I'm a student of second year law college from Indore Institute of Law.
Thank you.
Thank you. Honey Thomas?
Good evening, sir. I'm Honey Thomas from Bishop Cotton Women's Law College, Bangalore, and I'm a third year student of LLB.
Thank you.
Thank you. Khushi Chaudhary?
Good evening, sir. I am Kushi Chaudhary from Chanakya National Law University, and I am a second year student.
Okay, thank you. Likita M?
Good afternoon, sir. Myself Likita. I'm studying fifth year BBA LLB in Bishop Cotton Women's Christian Law College.
Thank you.
Thank you. Megha Vishwanath?
Good afternoon, sir. Myself, Megha Vishwanath. I'm a final year BBA LLB student from Bishop Cotton Women's Christian Law College, Bangalore.
Thank you.
Thank you. Michelle Ann?
Good afternoon, sir. Myself, Michelle Ann James. I'm a final year BBA LLB student from Bishop Cotton Women's Christian Law College, Bangalore.
Okay. Great. Thank you.
Muskan Narang? Sorry. I'm sorry for pronouncing it wrong. Muskan?
Yes, hi. My study I am Muskan Naran. I'm a second year law student from DY Patil University in Navi Mumbai, and I'm in second year from BA.
Thank you.
Okay, thank you. Neha Kothari?
Good afternoon, sir. This is Neha Kothari from Indore Institute of Law, pursuing BA LLB third year.
Okay. Thank you.
Nashra Siddiqui? Nashra Siddiqui? Do we have you with us? Okay. Priya Bhatia? Priya Bhatia? Okay. Rishabh Jain? Okay, sorry. Sorry.
Good afternoon, sir. This is Priya Bhatia from Banaras Hindu University. I am a student of BCom Honors second year.
Thank you. Rishabh Jain, go on.
Good afternoon to all of you. I am Rishabh Jain. I am a sophomore pursuing law from National Law University, Jodhpur. Thank you.
Thank you. Sahana R.
Good afternoon, sir. Myself Sahana from Sheshadripuram Law College, Bangalore. Second year.
Thank you.
Thank you. Sai Priya.
Hello, sir. My name is Sai Priya, and I'm final year student of BBA LLB studying in Bishop Cotton, Bangalore.
Okay. Thank you.
Thank you. Sherry Jacob Thomas.
Good afternoon, sir. Myself, Sherry Jacob Thomas, a final year student of BBA LLB, studying in Bishop Cotton Women's Christian College, Bangalore.
Thank you.
Thank you. Siddharth Singh. Do we have Siddharth Singh with us?
Good afternoon. This is Siddharth Singh, second year student of LLB second year, currently studying from Srinagar Law College, Pune.
Thank you, Subhas. Thank you.
Simran Patil.
Good afternoon, sir. This is Simran Patil. I'm a second year student from National Law University, Aurangabad.
Thank you, Shivan.
Thank you. Simrandeep Singh.
Hello everyone, I am Simrandeep Singh from ULS Chandigarh,
ULS Punjab University, Chandigarh. I am a fourth year student of BLLB. Thank you.
Thank you. Surut Srihari, if I pronounced your name right.
Good afternoon, sir. I'm Suhrit Srihari, a second year law student from PRR Law College, Hyderabad.
Thank you.
Thank you. Syed Renoba. Do we have Syed Renoba with us?
Yes, ma'am.
Renoba, we can't. You've not unmuted yourself.
Yes, ma'am.
Good. I think Renova is my student, na?
Yes, sir.
Yes. Yes.
Okay. Fine.
So you introduce for other intern, na? You should get to know each other.
Okay, sir.
Yes.
Okay. Do we have Urvashi Trivedi with us? Urvashi Trivedi. Okay.
Ma'am, she's texted on the group.
All right, fine. Then Vishwendra Prashant. Vishwendra Prashant, are you here? Yashi Mishra.
Hello, ma'am. Ma'am, it's Yashni. Good afternoon, sir. It's Yashi Mishra this side. I'm a second year BLLB student pursuing it from RSLW Jaipur. Thank you, sir.
Yeah, I'm sorry for pronouncing your name wrong.
It's all right, ma'am.
Yes, sir. Now the platform's over to you, sir.
Okay. So on behalf of the organizer, I'm welcoming all our intern. Means not only intern, all our respected intern, which that is the adjective which I have used. I have learned it from my teacher cum PhD supervisor, Professor M. Momin, who asked me to address all the students as respected students. So that is, I am repeating my learning. So you all are welcome to this internship program, which will be a serious internship program because this will teach you the skills, okay, which is not ordinarily taught in the law schools. Okay, in the, as you know, in the law schools only the mostly, not, I should not say only, mostly the theory part, law provisions are taught, but the gap which you will face in the practice life, that the skill which you require to apply the law, that is missing, okay, in the law school mostly. So RTI, this RTI Act is a very useful tool which will also help you in the practice life. To practice law, this RTI law could be a great tool for you. Okay, so I'll give some examples when I will be discussing the main session, okay, as to how you can use this RTI as a tool to practice in a better way, means practice law in a better way. Okay, so this is the one part that is welcoming you, and that is as you all are going to be a practitioner primarily, and then some of you could be a judge, some of you could be law officer, and you can choose other lines as well, that is other sector like corporate sector, etc. Okay, so so to start the internship, I would like to emphasize on why RTI, why you should study this RTI Act and the relevant drafting skill. Okay, so this is most important. If you know this, then that will help you to do the internship in a better way. So that is why I wish to make you familiar why you should emphasize on learning this very particular law and the required drafting skills which you should learn to apply this law. Okay. So first of all, you know, India is a democratic country, isn't it? And who runs the country? Who runs the country? The country is governed or run by those who are either directly elected or indirectly, I should not say elected, are selected by the elected authority or by any authority appointed by the elected authority. Like, you know, that is the MPs, legislature are directly elected by us, and the officers, okay, officers like IS officer, IPS officers are selected by Public Service Commission, either Indian or state. Okay, in the state, civil services are there. So the members of the Public Service Commissions are again appointed by the elected government, isn't it? So that's why I said that country is governed either by the elected personality or by the person who is selected either directly by the elected person or elected personality or by the person or authority as appointed or as selected by the elected person. Okay, so they are in the position of trust. Okay, they all are the trustees for us. Okay, they all are the trustees for us. What does it mean? That they should work. Okay, they should work only in the interest of us, in the interest of citizen. They should not work for their own personal gain or for their personal interest or for the interest of any other person with whom they are related with, which is the common practice now. Okay, you know, corruption is everywhere. You know that quid pro quo is everywhere. You know that even official bias, you have studied in, I think most of the students have already studied administrative law. So you know the bias thing, personal bias, pecuniary bias, official bias. So all this works, okay, and which ultimately result into the what should I say, that disregard of the protection of public interest, that is the protection of interest of ordinary citizen. Okay, so as these public officers are in the position of trustees, okay, we have reposed trust, okay, to work for us. So we are legally empowered to know as to what they are doing and how they are doing for our own interest, for the protection of our interest. Okay, so that is why that whatever they are doing, okay, so that should be placed in public domain, or if it is not placed in public domain, then there should be some mechanism so that we should come to know as to what they are doing and how they are doing. Okay, then only you can say that what they are doing, it is in our protection, it is in our interest or in the interest of the ordinary citizen of the country, and how they are doing, if we come to know, then we will also be familiar the method which they are applying to do the particular work, whether that is in public interest or not, that is in our interest or not. A thing can be done in public interest, but the way it is done, okay, can be done against public interest. Like in a road, development of a road, like village road or road in municipal area or in a metro area or town area. So development of the road, obviously it is in public interest. Okay, but if in the tender process, if there is any corrupt practices involved, like the PWD department, so suppose outsourcing the work for the development of the road construction to someone, okay, or to some civil contractor. Now, if that officers of the public authority who are there or who is there in the tender uh, giving process, if he accepts bribe from somebody, from the civil contractor to whom the tender will be given, to whom the work for construction of the road will be given, then definitely the quality of the road will be bad, isn't it? Because whatever money the civil contractor will get from the government, from that a particular amount is required to be given back to the public officers of the PWD, Public Works Department, because of which he is getting the work. Okay, so what the government has decided or PWD has decided, it is obviously in our interest, but the way excuse me, but the way it is done, it is going against the public interest. So one example I have given. Okay, so we need to know that what the government is doing or its functionaries are doing and how they are doing. These two things are very crucial, sir, interconnected. Okay, if we don't keep an eye on this, if we don't keep an eye on this, means what the public officer is doing and how he is doing the act or how they are doing the act or doing a particular work in our interest, then the sufferings of us is certain. Okay, if we don't monitor as to what the public officers are doing, okay, then sufferings will be there. Like what example I have given. If a civil contract manage a tender to construct a road in a village by giving some bribe, then the road quality of the road is going to be bad. And if it is going to be bad one, then after the construction, within 1, 2 or 5 months or 6 months, the road is definitely going to be damaged. Okay, and if the road is getting damaged within a few months, then we need to use the damaged road, and then damaged road is definitely be the reason of accident, and that accident might cause the injury to us or even may cause the loss of life of any people like us, isn't it? So why it is happening? Because we are not monitoring, because the citizens of that particular area are not taking interest to know what is happening and how it is happening, what the public officer is doing and how they are doing. And the very serious concerns here is that I hope you all can realize why you don't ask, why you don't take steps to know what the public officers are doing and how they are doing. The reason is that, might be you are familiar with, but I am mentioning this. The reason is that, in any public work, the politicians are involved, the high officials are involved, the great economic actors are involved, okay, businessmen are involved. So there is a great nexus in between the politicians, public officials and the business community. Okay, so they are always powerful than us. Why? Because they are having the power in their hand. Like if it is a politicians or if it is a public official, they are having the power in their hand. They can act against us at any time with a malafide intention. Or if it is a businessman who is acting on behalf of the government, we don't raise any voice against that businessman. The reason is that if I use or take any action against that businessman, then he can use his influence. He can channelize the politicians or the public servant officer or both of them whom he is feeding, because he is giving bribe to them. That is why he is getting the work. Okay, so he can easily use them to create hurdle or create disturbance for me. That is why you will come to know that several times when the ordinary citizen, even the students, are protesting against the government's actions or against the actions of any agencies of the government, or against the actions of any private entity who are acting on behalf of the government or with the government, like in PPT model, okay, or in the examples which I have given, when the government is outsourcing its work. So they are being implicated in criminal cases. They are being implicated in criminal cases, isn't it? Like, you know, that is a national, Citizenship Amendment Act. Okay, so there is a movement. Even students got arrested. Even one pregnant woman also got arrested. She is from a particular university. Recently, she has given a birth to a baby, that is boy child. Okay, so she was in jail, even in pregnant condition. Why? The reason is that she is protesting against the government. Government is misusing the power, law. Okay, you know the Dr. Kafil Khan's case. So he acted in the interest of the protection of the right of the child. In Gorakhpur case, I hope you should be familiar with this Kafil Khan case. If you not, you can Google it. So Kafil Khan, what he did, that there was no oxygen stock in the Gorakhpur hospital where he was acting as a pediatrics. So he asked the outsiders to supply the oxygen to save the life of the newborn babies. Okay, so actually what he had done is actually showing the deficiency of the government, the lack of government attention, that in every public health center like hospital, etc., there should be a sufficient stock of the required material, required things, which the doctors treat the patient. Okay, so the action of Dr. Kafil Khan exposed the, what should I say, that is carelessness of the public officers, and now he booked under the several laws. Okay, so whenever you are acting, whenever you know that it is your right, that you can ask the public servant what he is doing, let inform you, and how he is doing. Both the things you can ask from the public servant. Even verbally you can ask. That right was always there. Okay, that right was always there, but there was no legislative framework as to how to enforce that right, how to exercise that right, that is the right to know. Okay, so this act particularly made this thing a reality, that yes, we have the right to know whatever the public servant is doing and how he is doing, or she is doing, or they are doing. Okay, so here a legislative framework is now available under the RTI Act, for which this RTI Act was passed, which you will be knowing. Okay, so how to ask, where to ask, and if the asking is not respected, then where to go, like where to ask before the public service, public information officer. If it does not respond, where to go, where to approach, that is the Information Commission or the First Appellate Authority, that you will be knowing after studying that particular act. Okay, so that is structured now under the RTI Act, about which I will give a brief introduction after discussing this. Okay, so the main crux is that all public servants are trustees. Okay, and they have to act in such a way that we should come to know it. Okay, and they should be responsible as to what they are doing. Okay, so being transparent and being accountable is the obligation of the public servant, whether he is a minister, whether he is a IS officer, whether he is a state civil service officer, or whether he is a clerk. Okay, or whether he is any group D staff. So he needs to be transparent and has to be accountable for whatever he is doing. If he is not, we can ask for that. Okay, and this is the instrument through which we can make our public officer transparent and we can hold them accountable. Okay, that is whatever they are doing, we can hold them responsible for that. Okay, so and this is the tool through which you can do it. So this is the first phase, that why this RTI Act is been introduced, that is to ensure that the trustees of the public, that the trustees of the citizen should take care of their action. That if they don't take care, then they, at least it will be in their mind that there is an act which any member of the citizen can use to know as to what he is doing and how he is doing. And if he is not doing it in a right way according to law, then there could be a punishment, isn't it? So there will be fear in the mind of the public that whatever I am doing in writing, any member of the public can get it, unless and until it is fallen within the category of exempted information. Although you can get the exempted information if you can prove that public interest demands so. Okay, about that I will come to next, when I will give you a brief introduction of the RTI Act. Okay, so when RTI Act has been implemented, the government official has taken it very lightly. But when the ordinary citizen, even I can give an example. Why I am giving an example? Because that will inspire you to use this RTI Act. There is an example from from a panchayat area. Okay, that is a local government in Bengal. Okay, where a farmer has applied for knowing the status of his old age pension, whether he is going to get the old age pension or not. I hope you all are familiar with the old age pension thing. So who are belonging to below poverty line and a senior citizen cross 60 years, they are entitled to get the old age pension from the government. After getting the application, BDO remained silent. BDO did not respond to the RTI application. Okay. Now, thereafter he has made an application. Obviously, he has taken the help from local NGO and then applied, when he preferred a first appeal before the first appellate authority of the BDO office. He again remained silent. Then he moved the Information Commission, and that oh, sorry, excuse me. That Information Commission imposed penalty of rupees 25,000. Okay, see the power of the RTI Act here. That one ordinary illiterate person applied to the BDO, PIO office, PIO even did not think that it is his responsibility to respond to that senior citizen. Means taken lightly, and you can say it is the attitude of the public officers. It is the attitude. It is the colonial attitude. Okay, they think they are the master and the ordinary citizen are the servant. So that is the attitude of the public servant. And this public servant got penalized with rupees 25,000 along with a disciplinary proceeding against him for not responding to RTI. So even an illiterate person can, with the use of RTI Act, can penalize the civil servant, not only penalize him, also can ensure a disciplinary action against him. So this is not a simple act. This is not a simple action. because any ordinary man can do it. Okay, so this is one inspiring examples. Even I have got inspired with this case. Okay, so another example I am giving, that it's a case of 2013, even from West Bengal. So you know that college teachers are selected by the College Service Commission of the state. So one candidate applied for lecturership in Sanskrit subject. Okay, so he had all along first division, first class, and he had NET and he had also PhD. Okay, and there was only one vacancy. There was only one post for this subject, one lecturer. Okay, for general candidate. So there were 5 candidates applied for. Okay, now the selection was made in respect of a candidate who was having only NET, National Eligibility Test. He has qualified, but he had no PhD. He had also not first class in every exams like 10th level, HS level, graduation, and post graduation. He has not first division in every exam. So now from these two things you can say that who is having better qualification, he should have the chance to be selected, isn't it? So because the academic quality, academic API score is there. Okay, so according to academic qualification, some marks are allotted. According to publication, he has a good number of publication, and the fellow who got selected, he was lesser number of publication. Now when the result was published, this candidate who was having PhD all along first class and NET, he got surprised that the candidate who has been selected, he was not even having first class in every exam and not even a PhD. So how he got selected? So he has applied for getting information that what marks has been given in academic matters and in interview. Okay, so College Service Commission remains silent. Then he has preferred an appeal before the College Service Commission, first appellate authority. He also remains silent. Okay, now after you know that after filing application you need to wait ordinarily for 1 month, and if the information officer remains silent, then you can, after 1 month, you can apply for first appeal, and thereafter, after waiting for 45 days from the date of filing of the appeal, you can apply for second appeal, or you can prefer a second appeal before the Information Commission, Concerned Information Commission. So when he preferred a second appeal, on the date of first hearing, the College Service Commission did not appear. On the second date of hearing, when the court said that if you don't appear on next date, the College Service Commission will be penalized for disobeying the order of the Information Commission. Then College Service Commission appeared and asked for time, that give us 1 month so that we can respond to the appeal. And thereafter what happened? After the court adjourned the matter, after 2 days, that candidate got a call from the College Service Commission chairperson. And College Service Commission chairperson asked him to come down to his office. And there, when he met the College Service Commission chairperson, College Service Commission chairperson said that I have no hesitation to say or to disclose to you. If I don't say, obviously Information Commission, it will get disclosed. So that is why I am saying you that we were under pressure. We were compelled to take the candidate who was having a reference from the sitting minister. Okay, so we cannot contest the appeal which you have preferred before the commission, but we need to save us. See, the College Service Commission chairperson is saying to that candidate that you need to save us. So he got surprised. So said, sir, how? So said that you should not proceed with the appeal. We will create a post. Some professor has retired. So there are some vacancy. We will create a immediate vacancy, and in that vacancy we will appoint you. So that candidate has accepted that proposal. Okay. And thereafter he was given appointment. Because in every appointment, appointment advertisement or vacancy advertisement, you will find it is written that the number of vacancy may increase or decrease at the discretion of the commission, isn't it? So they always have the power to increase or decrease the number of the vacancy. So the College Service Commission created a vacancy and given offer letter to him, and thereafter what he did, as per the chairman's request, he withdrawn the appeal. He said that, sir, as I have got the employment, so I don't want to proceed with the appeal. So this is another power of the RTI Act. Even when you got deprived of your service, even this RTI Act can help you to get an appointment. Although it will not happen in every case, but it has happened even in a single case, and that we all need to acknowledge that this is the power of RTI Act. Okay, so these are the two examples. Okay, so and with this I will end this introduction about why RTI with this last statement that to implement which constitutional provisions this RTI Act has been enacted or legislated. So that is, that is the under Article 19, you have the freedom of speech and expression. Okay. So to enable the citizen to use or exercise that freedom of speech and expression in a better way, this RTI Act has been enacted. Because to express ourselves, we need information. Without without information, or better say, without correct or accurate information, we cannot express ourselves rightly, correctly, isn't it? So suppose you have heard about a corruption, that yes, a public officer involved in a corrupt practice. I can remember the name of the IS officer, name is Gautam. There was a flood in Bihar. So that IPS officer was charged with corruption with the relief material, okay, in procuring relief material. So suppose you got interested to give an allegation against that kind of officer, about whom you have heard he is engaged in a corrupt practice. But without having any information, how can you label the allegation? Isn't it? So you need to have some authentic document. You need to have some authentic information based on which you can express yourself. When you are complaining something, you are expressing. When you are appealing for something, you are expressing yourself. When you are requesting someone, you are expressing yourself. Isn't it? Either with your desire, with your need, with your enjoyment of right, whatever it may be. So you are expressing yourself. So without authentic information, either it could be in documented form, okay, or it could be in electronic form, soft copy or hard copy, okay, because with the oral information or oral statement about which there is no record, you should refrain yourself from making an allegation or from expressing yourself. Because about which there is no record, what person has made the statement, he can just deny that. So to be in the safe side, you need to have some authentic information in accepted format, okay, documented, electronic, etc. And after having that, you can express yourself. You can libel allegation, you can file a complaint, you can file an appeal, you can make a request, whatever it may be. Okay, so this act is there or enacted to enable the citizens to express themselves after obtaining, when they want to say something about public officers and public officers. Okay, so they should get the information from the public officers first, and then they can express themselves either in the form of making allegation or whatever it may be as per his choice. Okay, so your background work you need to do. Okay, and you can do your background work with the use of this RTI Act. Okay, so this is the brief about the RTI Act, why RTI, or why you should learn about RTI, or why this RTI Act has been enacted. So this is the purpose and this is the use. I have tried to explain it with some examples. Okay, so this is the introduction about the importance of RTI. Now coming to your internship. Okay, so the internship goes like that, that development of drafting skills under the RTI Act. So whatever I just said, that you need to express. How you can express? You can express either verbally or in written form. Okay, so when you are approaching any public officials, okay, if it is not allowed under the law to speak orally to the public officers, you cannot talk to them orally. Okay, you have to communicate with them in writing. Like if I take an example of FIR, under the provisions of section 354, so for 354 or 154, FIR, I forget. So I think it is 354. 154 or 354? 154.
Yes, sir. 154.
Yes. So it is FIR in cognizable case. Okay. So under these provisions, you can write the grievance on a paper and you can give the officer to treat it as an FIR. Okay. So if you have the capability to write it in on a paper or with the help of someone to write the same on a paper, and when you are not in that position, you can go, you can say verbally, the police officer will reduce your verbal statement in writing, and then it will be treated as a FIR after taking your signature. So here submission in written form and oral form is allowed, but can you submit a civil case verbally? Can you go to the civil court and say, sir, my neighbor is creating nuisance on my land, or he has trespassed on my land, so kindly issue an order of injunction? Will the court do it? The answer is no, because here you need to submit in writing. Obviously, in some cases, you can approach the court in writing, and what the court will do, court will say, so please submit in writing. Court will hear you and court will say submit in writing. Like in cases of suo motu matters, serious matters, you can approach the court that such an grave incident of violations of constitutional right has happened in such and such place. So kindly we urge the court to take the suo motu cognizance. So on that occasion, court, on the basis of verbal presentation, court can take suo motu cognizance. So it is allowed. Court is empowered to do it. Okay. So court is having inherent power. Court can do anything at the ends of justice, for the interest of justice. Clear? When the express provisions of law is not present or absent. Okay. So the drafting means preparing the document. For what purpose? To ensure the exercise of the right, or in other words, you can say to ensure the remedy for the violations of right. Okay. So here one part will take care of that drafting or application, like RTI application. You want some information, you have to apply before the concerned authority, who is known as public information officer. So you have to give in writing, and when you are giving in writing, you are applying for the purpose of exercising your right to information. You have a right to know, so that is why you are applying. So you are exercising your right to information. Okay. And if you remain silent, then you need to approach before the higher authority, appellate authority. So here you are asking for remedy, that you had a right, that the information officer should have supplied you the information, but he has not supplied the information, or he has supplied the information which is incomplete, or he has supplied the information which is not correct, or which is misleading. Okay, incomplete. So in this case, you will approach the higher authority to ensure remedy, that whatever the act is committed by the public information officer contrary to law, for that whatever remedy is available, please revert to me. Like first order, first remedy, that he information officer, appellate authority can direct the public officers or public information officer to give the information as requested. One. Second remedy is you can ask for disciplinary action against the public information officer. Second remedy. Third remedy is that you can ask for imposition of penalty for every day of delay in filing, in supplying the information. After 1 month of filing of the application, 250 penalty will be imposed on the information officer. So you can also ask for this remedy. And fourth remedy, if any loss has happened, you have suffered loss because of the non-response, or because of the silence, better I say silence, or because of no decision on your RTI application, and because of that you have suffered some financial loss. For that you can also apply for the remedy that is known as compensation. Okay. You can also apply for the remedy if there is no information officer. You can also ask for appointment of the information officer. Okay, so there are numerous remedies where your RTI application is not decided. So in appeal, you can ask for that. Okay, so that is why I said that we draft either to exercise our right and or to get remedy for the violation of our right. Where the RTI application is not acted upon, that is the public information officer remains silent, it means he has violated your right to get the information within 1 month. Or suppose he has applied, but he has supplied you, sorry, he has decided, but he has supplied you the wrong information, misleading information, or incomplete information. So that is also violation of your right. So you, for that you are entitled to get remedy by approaching the appellate authority or higher authority. Okay, so that you can do. Now, for drafting, you need to know the law itself very clearly. If you don't have the idea about the law under which you are drafting, okay, or under which you need to prepare a draft, you will not be in a better positions to draft correctly. So you need to have a good knowledge about the provisions of the RTI Act. Okay, so that is why yesterday I asked Asma to share with you the RTI BR Act of the RTI Act. Okay, so I have supplied this BR Act with Asma. Hopefully Asma will supply it to you. So you need to study.
Yes, sir, I will share today.
Yes, so you need to study those particular act, the relevant provisions. Okay. So which I will be stating after this. Okay. So here, what kind of document you need to, or you will learn to draft. Okay. So in this act, you need to draft either, means mainly three type of excuse me, mainly three type of document. So first document is application. That is the application through which you will ask for supply of the information. Okay, so that is the first document or the first draft which you will learn as to how to prepare it. Okay, first document which you will learn to draft. Second is, if your RTA application is not acted upon, not decided, or decided not rightly by supplying misinformation, misleading information, incomplete information, okay, then you need to learn to draft two kind of document: first appeal and second appeal. Okay, so how to draft appeal, either first appeal or second appeal, you will learn here. And third important document, suppose you have applied for information, information will remain silent. You applied for first appellate authority for supply of the information, first appellate authority in the same department remain silent. Then you need to go to the information commission, either state or central, as the case may be. Okay, so you need to draft the second appeal. Okay, so this is one way, and another way to, not I will say they get the information, but you can get the information indirectly. I will tell you how when I will help you as to how to draft the complaint. COMPLAINT, complaint. So don't get confused that complaint and appeal are same thing. Okay, often the students are having the misconception that complaint and appeal are same. Complaint is filed under section 18 of RTI Act and appeal is filed under section 19 of the RTI Act. Keep in your mind. And the remedies, there are similar remedies under the appeal or complaint, but there are also distinct remedies as well. Okay, under the complaint, the court will never be able to direct the supply of the information. Okay, but under the appeal, court will be able to direct the information officer to supply the information. That is the major difference in remedies in appeal and complaint. And in complaint, you can ask for the investigation. Okay, in appeal, information will be provided, but whether it is correct or not, you cannot judge. But in complaint, you can ask for the investigation, or you can get an order for the investigation through which you can by yourself, that is the complainant, can verify the official record, all the relevant records, and then you can take the required one as a Xerox copy or photocopy. Okay, so that I will help you to learn as to when you should file a complaint and as to when you should take the path of appeal. Okay, so in every cases the path of appeal is not right, and in every cases the path of complaint is also not right. So you need to decide which path is right. Should you file after the rejection of the RTA application or decision on it wrongfully? Should you go for appeal or should you go for filing complaint? That you need to decide, and you need to be wise enough for that which remedy is suitable for your instant case. So you need to decide. If you are not in a position to decide, you need to take help from the expert or senior lawyers or your senior friends or any activist who is engaged in this field. Okay, so this is the very purpose of this program, that you will focus on the drafting skill only. But without focusing on the provisions of law, we cannot achieve the aim or objective of our internship. Okay, so you can, as I said at the outset, that you can only draft rightly, appropriately, only if you have the knowledge of the law, of the relevant law, the relevant provisions. So that I am referring those provisions, I will ask you to write down, or even I can also send it or mention it in the group for your reference. So few provisions you have to study. Okay, if you study those provisions, that from next day or from tomorrow, you will be able to understand whatever I will be teaching to you. Okay, or whatever I will try to help you to learn. Okay, so first is you need to understand the most important thing, what is information. So section 2F, section 2F is the definition of the term information. Okay, so which are regarded as information, any record in any form available with the public office. Okay, so that is information, whether it is in electronic form or otherwise. Okay, even one brick, if one brick is available in the public office, okay, even the brick with which the wall is made in the public office, even you can ask for that. Okay, suppose I am giving an example. Suppose a construction work is going on in your university. Suppose it is a state funded university or it is a private university. Private university also amenable to RTI Act. Mostly the private university don't follow this RTI Act, but it is bound to comply with the RTA provisions. Okay, so suppose a construction was going on in your university and you came to know that grade 1 quality of the brick should be used in the construction work. Okay, now you have come to know that the constructor, in connivance with the registrar of the university, is using B grade of bricks to develop the construction work. Okay, now that second quality of good, second quality of brick, okay, you can file an application and you can get a sample of that to check whether the brick is being used by the constructor to develop your university's construction work is of grade O quality or not. Got the point? So whatever is available in public office in any form, you can get it apart from documents. So I am showing even the bricks can be regarded as a document. Okay, or information. Like suppose the construction work is already complete. Okay, now within 1 year there was a crack in the wall. You'll find in the government university it is happening, or the tiles or the marble which is used in the washroom, that is of bad quality. Okay, that gets darker within 2 or 3 months. Okay, white quality of marble is getting darker and darker with day by day. What does it mean? The quality of the marble is of low grade. So even after that, you can file an application, you can take that, or you can take the concerned officers by filing an application through getting an order of investigation by the Information Commission to check whether that marble was of that quality, which, or that bricks of that quality which the constructor was supposed to use under the under the tender. Because in tender you will find one works order. Works order narrates detail what quality of goods is to be used in the construction work. So you can take the concerned parcel through the order of the commission to check whether the correct quality of goods has been used to raise the construction or not. Okay, so what is information? Whatever is available in the public office, you can get it. Okay, unless and until it is prohibited under section 8. Okay, so this is the information. Information meaning is need to be you should have a clear idea what is information, because you are going to ask the information. Okay, so if you have don't idea, or if you don't have any clear idea as to what constitutes information, okay, you will not be able to draft your RTI rightly. Okay, so you have to have a great knowledge of, or not, even if not a great knowledge, even if a knowledge of plain reading of the definition of the information. Okay, so information, what is information? That is you need to study. So section 2F. After that, you need to know what is right to information. Okay, information is there, and what is right to information? So right to information is defined under section 3. Okay, So that you need to study. Okay, I am not going to discuss this. You read it. If you find any difficulty, I'll respond to it. Okay. So right to information is the section 3. Right to information. Just a minute. And you have to read section 3, right to information, with section 2F. Okay, because section 2F has defined what is right to information. Okay, so here right to information is not only for making an applications to get the information. Here right to information means inspection of work, document, records, which I just uttered, that what quality of goods has been used in the construction work in your university. So you can go and inspect the work as well. Okay, then taking notes, you can go and take notes by filing an application of the official record. Then taking certified copy. Okay, okay. So it's a broader definition, or right to information is having the broader purview. Okay, so it's the right to information has not been defined in a narrower sense. It has been defined in a broader sense. Okay, so section 2F should be studied with section 3. Why I am asking to read this 3? Because this 3 says that this right to information, which has been enumerated under section 2F, okay, subsection F, section 2, that this right to information only available sorry, excuse me, only available to the citizen of India. No foreigner is having any right under right to information act. Keep in your mind. So foreigners cannot make an application under this right to information. So section 3 limited this right to information to citizens only. Okay, so that is why I said that you should study section 3 along with section 2 subsection F. Okay, so that is about information and right to information. And thereafter you need to study section 4, obligation of public authorities. So there you need to study the definition of the public authority in the definition chapter. I am not going to refer it. You need to find it. You also have to do something by your own, because doing the thing by your own brings a great joy. So that is why I am not referring the section of the definition of public authority. You need to do it by yourself, because here I want to refer one burning issue. You all know about PM Cares Fund. PM Cares Fund, which has been created by the Prime Minister Office to deal with this corona pandemic. Okay, so they are saying this PM Cares Fund is not a public authority. So you need to judge whether the PM Cares Fund is a public authority or not after going through the definition of the public authority as has been defined under this definition section. Okay. So thereafter, what are the obligation of the public authority? Why PM office is denying that PM Cares Fund is not public authority? Because if it accepts that PM Cares Fund is a public authority, then it will be coming, or it will be compelled, or it will be under an obligations to comply with the RTI provisions to give all the information related to PM Cares Fund. Okay. So you just check that whether PM Cares Fund should come within the purview of the definition of public authority or not. So if it is a public authority or any other public authority, what is their obligation under the RTI Act? Okay, so they have the obligations to appoint public information officer, or to designate public information officer, or one or more, okay, for a single office, or to appoint or designate one officer as first appellate authority in every department. Okay, so That is the obligation of the public authority. Apart from that, one important provisions is there under section 4, that is proactive disclosures. Proactive disclosures, that no citizens needs to ask about that information. The public authority by its own has to declare or has to upload all the relevant information in its website. Okay, or if website is not available, in the notice board. Okay, so some information you will automatically get as per the promise of the RTI Act, either in the website of the concerned public authority or in the notice board of that public authority. If it is not available, then you have to apply for getting that information. Okay, you will find compliance of these proactive disclosures by many public authority, but at the same time, you will also not find any, not even a single compliance of proactive disclosures by several public authorities. Like I will take the name of different private universities. Okay, they even don't care about this. Okay, different NGOs, some NGOs who are getting government fund. Okay, so they are not they are not claiming PM Care Fund is a, what should I say, is a NGO. It is a trust, but it is not a public authority. Okay, so if you can establish that PM Cares Fund is a public authority, you will find in near future that the court is going to declare, or court is declaring that PM Care upload all the information under the proactive disclosure mandate. But means that by its own the public authority has to disseminate some information. So you need to check that proactive disclosures item which the public authority should disseminate by their own, either through their website or through their notice board. And thereafter, the most important provisions you need to study is section 6. Okay, that is request to obtain information. Okay, so that is the application for getting information. So under this, you will find the RTI applicant's obligation. Whenever you are applying, you have to give 10 rupees. Okay, and either in the form of IPO or in the form of court fees or in the form of cash payment or in the bank channel as permitted by the rules. Okay, so you can ask, sir, can I file an application under without making deposition of the payment, or can I file the application through email? The answer is yes, you can file the application through email without making deposition of fee. Okay, even you can send the application through post without making any deposition of fee, but the public information officer has the right to demand the fee within 30 days. If he does not demand, then you will have no obligations to pay the fee. So even if you, when you are having no money, you can send the application through an email. Okay, let him ask for the payment of the fee. If he forgets, you will have no obligations to make the payment of the fee, not even a single paisa after 30 days. Okay, and sometimes we find that application through post or in person takes time. So you can find the application through email, and thereafter, if you are honest enough, you can find the you can submit the payment, that is the application fee, through post or otherwisely in person. Okay, but your application's date will be effective from the date of payment. Okay, so if you don't make payment and the information officer also forget to ask you to make the deposition of the payment within 30 days from the receipt of the application of the that is the application of yours, then the validity of your RTI application will be from the date on which you have applied. But if the information officer asks for the payment, then the date on which you will make the payment, from that date, validity of your RTI application will get started. Okay. So this is the thing. And one important thing I would like to mention, that how to dispose, what are the obligation of the that is the public information officer. So you need to know the authority duties, his right and obligation, and you also know who is submitting the application, what is his rights and obligation. Because if you comply with your duties, that will enable the other side to discharge his duties at the earliest. Okay. If there is a lacuna in discharging your duties, then certainly the decision on it is going to be delayed. So if you neglect the payment of the fees, then decision will also come late. So it is wise that if you submit the fees on the date of the application, then that is good, because that will ensure that your application might be disposed at the right point of time, but which does not happen often. But you need to discharge your own duty. Okay. So how applications should be disposed of by that PIO, you should know it, because if you don't know it, then you will not be able to follow the subsequent step. If you don't know within how many days the application should be disposed of, you will not be able to file a first appeal or second appeal, isn't it? So you need to know both sides, duties and obligation, yours and officers. And Section 8, some informations are not allowed to be disclosed, so you should have a good idea about it. And if you want the disclosure of it, then you need to ensure that the public interest outweighs the exemption clause. Means the disclosure of the exempted information, that is which is not ordinarily to be disclosed, is weight of it is higher than the exemption, than the non-disclosure. Okay. So then only you can get the disclosure of non-disclosing or what should I say, ordinarily not disclosable information, which is written down under Section 8. So don't take it that whatever is coming under the exemption clause Section 8, that it will not be disclosed. It is not. It will not be disclosed ordinarily. But if you can prove that the public interest demands the disclosure of that not ordinarily disclosable information, if you can satisfy the information officer or the information officer or commission, as the case may be, then even the information which is enumerated in Section 8, that can also be ordered for its disclosure. Okay. So under the right to information, every information can be disclosed if it is in public interest. That you need to prove. So public interest always outweighs the weightage of secrecy. Okay. Then Section 9, ground of rejection. Under what ground the officer can reject your application. And Section 11, you should study that third party information. So if you ask any information relating to third party, which is not concerning the government officer, any individual, public individual is concerned, then in his case, he should be heard before disclosing his information. So if you ask any information about your classmate mark sheet, suppose, okay, so classmate is not falling within the ambit of public authority, he is not concerned. So if you want to get information of his mark sheet, you have to prove that public interest demands so. Okay. And that person whose information you are asking, that is your classmate, he should be given an opportunity of being heard to object or to consent. Okay, that whether his marks should be given to you or not, he should be allowed or should be given an opportunity to have some say. He can say yes, it can be disclosed. He can say no. When he say no, then you need to prove that public interest demands the disclosure. Suppose you know that he has written only 2 pages in the exam and he scored 70 marks. You have witnessed that he has written 2 pages and he scored 70 marks. Then you can ask for the disclosure. You can say that there should have some corrupt practices because I have seen that the student has written only 2 pages in the exam. How he can score 70 marks? Then there is something otherwise. So if the information commissioner or information officer is satisfied, then he can order the disclosure of your friend's mark sheet, even or your friend's answer script, even there is an objection on the part of your friend. Okay. So this is that is section 11. And if your information relates to both things, one is ordinarily exempted and ordinarily not exempted. Sorry, ordinarily disclosable and not ordinarily disclosable information. One part of the information you have sought coming under section 8. So court will separate it. If it can be separated, then the disclosable information can be given to you, and non-disclosable, ordinarily non-disclosable information will not be given to you. That is the duty of the public information officer. So this is regarding application, and thereafter you need to know Information Commission's power. Information Commission's power, that is section 18, 19 and 20. These 3 sections you study. Okay. Section 18, 19, 20. And keep in your mind, this act is having overriding effect. Okay. This act will have upper hand against all other acts, which ensures or which says non-disclosure of the public information, like Official Secrets Act. So this RTI Act overrides the Official Secret Act, okay, or other incidental or relevant act. So this is the provisions you need to study. You need to know the provisions as enumerated under these sections, and when you are familiar with these provisions, then only you can develop a great drafting skill under the RTI Act. Otherwise not. Okay. So please study all these provisions, which I am also going to text you in your group, so that you can read or study accordingly. Okay. So today up to this. If any questions, query, if you have, you are most welcome.
Yes, sir. Thanks a lot, sir. So interns, please note, you can unmute yourself and ask questions. The floor is open for questions. Those of you who can't unmute yourself, kindly message. My co-moderator, Eliza, will at the end of, after the oral questioning is over, she'll read out the questions from the message box. So interns, yes, you can unmute yourself and start asking questions.
Good evening, sir.
Yes, good evening.
Sir, what is the position of army institutes and army schools with regard to the RTI? Since they are not exactly under the government this thing, but
see, you need to check. That the information. Should I respond?
sir, yes, sir.
Yes, sir. Yes.
See, the questions you have asked, I cannot really answer because without knowing the nature of the information which you want to ask, because you have to be specific, because there is a schedule. Okay, there is a schedule that is known as schedule 2nd. Okay, now you can sheet. I'm showing you, just a minute.
Sir, this schedule is under the Act.
Yes, schedule, you will find 2nd schedule. Okay, so
Yes,
there is a intelligence and security organization established by the central government. Okay, you talked about army. Okay,
yes, sir.
so Here, like intelligence bureau is there, like border security force is there. Okay, Indo-Tibetan border police force is there. Okay, Assam Rifles is there. National Security Guard is there. Okay, so these authorities are exempted from disclosure of any information except the information which is relating to human rights violation and corruption. Keep it in mind, which is related to human rights violation and sorry, excuse me, which is related to human rights violation and corruption. Now, as you referred to school, as you referred the army school, so now without, as you are not specific what kind of information you want to ask.
Just suppose if it is regarding appointment of teachers in army colleges or army schools.
Obviously, it means you are indicating corruption thing. If it's when you are not satisfied with the appointment of some teachers, so definitely it is not going to do it. It is not going to what should I say that
It is not any confidential
but
information.
it is not going to interfere with any intelligence matter of the state. Okay, so intelligence matters of the state, why it is being kept secret? Because if it is disseminated to the enemy countries, okay, they will take advantage of it. Okay, so that is why the they are put under schedule 2, that ordinarily their information are not disclosable. Okay, but if your information like appointment of teacher, or suppose one student has been marked low, okay, graded low, okay, or suppose one student is being harassed inside the school campus, okay, so you need to connect it with two perspective or with two respects, either it's relates to violation of human rights, as I said, like beating of the student, harassing of the student, or appointment of teacher as you asked. And obviously we are, when we do question the appointment of the teacher, when we are not satisfied about the selection process, when we are having some doubt, so when we are having the doubt, there should have some factor of biasness. As I at the outset of today's discussion I said, I hope you have studied administrative law. If you have not, then I'm saying that there are three kinds of bias. One is personal bias, or another is pecuniary bias, another is official bias. So suppose by taking money, if the appointment is given, pecuniary bias, corruption. Personal bias, suppose head teacher has given the appointment to his brother-in-law, that is also corrupt practices. Corrupt practice does not involve only the acceptance of the bribe, it includes abuse of the power. So suppose I am the head teacher and you are my sister-in-law, okay, and I am giving the appointment disregarding one good candidate only because you are my sister-in-law. That is why I am giving you the appointment. So this is the corrupt practice, isn't it? So that is why I say that if it is related to two things, if it relates to army organization, and if it is related to two things, human rights violation or corruption, then definitely you can file an application and definitely you will get the information. If not by the public information officer, by moving the information commission, you will get it.
Okay, thank you, sir.
Thank you.
Anyone else? Interns, you can just come in with your questions.
Hello, sir.
Sorry, one thing, one intervention, please. I'll take a question. See, I always encourage you to ask any questions, whatever is in your mind. Don't hesitate, please. Why I am saying so? Because your single questions can be a great learning point for me as well as of you. Okay, so as you wish to learn, I also wish to learn. Keep in your mind. So don't deprive me from the opportunity of getting learned. Now you can go ahead with the question.
As you earlier said that they get team.
Your voice is getting cracked. Your voice is getting cracked.
Hello.
Yes, yes.
Said complaint and the difference is remedy. So there is only one difference between complaint and appeal, which has been needed section 18 or section 19 respectively.
No, I was not able to hear your question. Sorry,
Intan,
can you repeat?
your
Or
connection
or
is slow or your voice is cracking. Can you maybe
yes.
disconnect and reconnect? Until then, anybody else would like to come in?
Or you can ask them to Himali. You
Yes,
can
sir.
ask them to text their question.
Okay, sure, sir. I'll do that.
Okay, and you can read it and I can answer it.
Guys, as you heard, sir, you can text your questions as well. So we have three questions.
Yes,
One
yes.
is from Gaurav Kumar Singh, who asks, what are the remedies when any wrong, misleading information is provided in RTI, in an RTI response, especially when State Information Commission and Central Information Commission face burden of such cases?
Okay, yes, yes. See, the first remedy when misleading information is provided or incomplete information is provided. Okay, so you you have two remedies. Okay, either you can prefer an appeal before the first appellate authority, whom you can find in the same office of the information officer. Okay, because the public information officer is the junior officer and first appellate authority is the senior officer to him. Okay, so you can go for appeal, fast appeal, but I will not advise to go you to that is the first appellate authority. Reason is that yes, the reason is that often the first appellate authority remains silent or don't act against the public information officer. Okay, but if you have chosen that path, you wait for the decision of the first appellate authority. That is 45 days from the filing of the first appeal, and if you remain silent, you can approach the information commission after 45 days of preferring the appeal. So that is one path, and another path is don't go for first appeal. You can directly file complaint under section 18 before the concerned information commission. Okay, so these are which path you will choose, that you need to decide. But I will say when misleading or incomplete or false information is given, I always encourage to file the complaint. Okay, and the last remaining thing which you have added in your question, when the information commission facing such amount of burden. Okay, so yes, that is a serious concern. That is a serious concern that information commission is facing the burden, but you need to understand they will face the burden because the government is not interested to appoint all the information commissioners. Okay, the commission is functioning with less number of uh, commission is functioning with less number of commissioners. That is, suppose their sanction strength is 10, then you will find the commissioner only 4 or 5. Even in the Central Information Commission, that is also functioning with less number of its sanctioning strength. Okay, so this is the practice of the government, that paralyze the information commission and discourage the RTI activist or RTI applicant. Okay, so you don't lose hope. The burden is the reality. The pendency of huge number of cases in any legal fora is the daylight reality. We need to accept it, and we need to act on it. Okay, what you can do, you are the law student. Okay, so one day you will be the advocate. So what we can do, that is why we ask for group work. So if there is a less number of commissioner, that is suppose two vacancies there. Okay, if uh, you are a lawyer, or if you are a group of lawyers friend, you form a group and you file a public interest litigation petition before the high court for appointment in the vacancy which is existing in the commission. So if it functions with full strength, okay, if it functions with full strength, then obviously the pendency will be lesser. One, and second is, although this is the hard work, and second is because why I am asking for this hard work, you cannot do it immediately. After passing the law, you can do it, and the importance is that with this work, numerous RTA applicant will be benefited. Whatever questions you are having might be nobody will ask it if the commission functions properly with its full strength. Now, even if the commission is having full strength, then also huge number of pendencies there. Why it is so? Because the commissioners are lethargic to act, because most of the commissioners are coming from administrative service. They don't want to act, mostly they don't want to act against the public servant. Okay, so they only adjourn the matter. They only adjourn the matter. That is why one case has been filed before the Supreme Court, and Supreme Court decided that the central government and all other state government should not only select the information commissioner from the administrative service and police service. It was the practice of the central and state government to appoint information commissioner either from the police service or from the administrative service. And you know, when they are from the same service, do you think they will be in a position, or they will take interest to act against them immediately or at the earliest? So they will not. So that is why you will observe that when the journalist is being appointed as a commissioner, when the law professor is appointed as a commissioner, probably you have heard the name of Professor Sridhar Acharulu, who is the law professor of the Nalsar, retired. Now he is in Bennett University. Okay, so Sridhar Acharulu, who ordered the disclosure of the information about our Prime Minister's master degree certificate by the Delhi University. Okay, and the day on which he has ordered, he has been removed from the cases of higher education. What the point? So see how the politics works. So here we need to emphasize, we need to create pressure on the government so that they appoint information commissioner from diverse field, which is the actual which is the actual provisions of the RTI Act regarding the appointment of information commission says that they should be appointed from the field of law, social work, journalism, engineering, public service. All right. So when the commissioner is going to be appointed from diverse field, okay, and when they are not having, or very maximum number of the commissioner is having no connection with the public officers who are being pleaded as respondent, then they will be able to act independently without any partiality, na? And you can hope that right judgment will come from them. So politics is there, government's willingness is not present there, that the RTI applicant get the remedy at the earliest, because you know even the Supreme Court is not pleased with the RTI provision. Okay, so when the judiciary is not open to accountability, open to transparency, can we expect it from the administration? So we should not lose hope. We need to do research. We need to show how the commissioner is functioning. If a particular commissioner is not functioning well, or more commissioner is not functioning well, we need to expose them through our research work. We need to expose them through our article. We need to expose them through filing public interest litigation. we need to compel the government to appoint the right persons with integrity to be appointed as public servant, not only from the field of administration and police service. Then only you can see the right thing is happening. Otherwise, we all will observe the situation what you have observed and raised in your question.
Thank you, sir. So the next question by Ghansham, which you've already answered, is if there's a difference between complaint and appeal. If there's a difference, is the difference only related to remedy, or is there any other difference?
Okay. No, see, not only remedy, in cases of cause of action, there is also difference. Okay, means there are certain cause of action, that there are certain reasons for which you can file the appeal. There are also certain reasons for which you can file the complaint. So, not only in remedy, sorry, excuse me, also in cause of action, there is also difference. Like one example I'm giving from my own experience. I was in 2010, I was in Tripura. Okay, so Tripura is the first state sorry, excuse me. Tripura is the first state which has introduced compulsory recording of marriage. Okay, in 2003. So chief marriage recorder. Okay, it was under chief minister office, chief marriage recorder. So in his office there was no information officer appointed at that time. So I have filed an appeal, I have filed an application. I found no response. Okay, so thereafter what happened? I filed complaint. I filed complaint before the commission, and in the commission, response was given by the state that they have appointed public information officer late. That is why they were not in a position to respond to my RTI application within the statutory period, that is 6 months. So, if the RTI officer, that is the public information officer, is not appointed, you can file a complaint. All right. So, if the RTI officer is not appointed, you cannot file an appeal. Okay, that is one. Second is, suppose you have filed an application to any public information office, and suppose it returned back to you. Nobody was there to accept it. Okay, so it means it's a refusal. So the office to which you have sent your application seeking some information, if you file an appeal in the same office, again it will come back. It is the natural expectation or natural consequence. If they refuse to accept your application, they will not accept your appeal. So in that case, if your application is being refused, okay, then you can directly approach the Information Commission. So I will urge you to read section 18 and 19. You will find the difference. Okay, so these two examples I have given, that apart from remedies, there are other differences also in appeal and complaint. What it? Two examples I have given.
Thank you, sir. Sir, the next question is by Yashi Mishra. It is, are the political parties also covered under the ambit of RTI? If no, why?
See, there political parties, there is a order of Central Information Commission. Okay, so that Central Information Commission in its order said all mainstream political parties, I can name them, I can name few of them, like CPM, okay, Communist Party of India, then Mayawati's party, Congress, BJP, etc. So there is a case against them. So Information Commission order that these political parties are amenable to RTI Act because they are accepting government donation. Okay, they are accepting government's what should I say? Government donation I can remember right now. Okay, so in the public authority, you will find in the definition of public authority, you will find that any NGO accepting government donation, okay, so or it is having control by the government officers or government, that will be regarded as public authority. Now you need to understand what is a political party. Political party is nothing but an association of person, okay, so which is known as, it is an NGO, non-governmental organization. So when it accepts the government fund, so it will come under the purview of public authority, and when it is come under the purview of public authority, it will be amenable to RTI Act. And in compliance with that order, Communist Party of India has designated their public information officer, okay. So there is an order, but that order of the Information Commission, Central Information Commission, has been challenged by the, I think, BJP and Congress. Both both have challenged, so far my knowledge goes. Okay, and that is pending. I think either before Delhi High Court. I think it is pending before Delhi High Court or before Supreme Court. Hopefully, it is before Delhi High Court. I have to check and cross check, and I have to respond. Okay, so you just get the answer that yes, there is an order of Central Information Commission when it has ordered that these political parties are amenable under the RTI Act. Okay, so you need to answer by yourself. Study the public authority definition. Okay.
Okay. Yes, sir. So the next question is by Siddharth Singh, who says, recently in news, there were 3 RTI applications that were filed for details
Himali,
of...
can you repeat? I missed it.
Yes, sir. I will repeat 1 second.
Yeah. Sorry.
So he asked, recently in the news, there were 3 RTI applications that were filed for the details on quashing of the VVPAT receipt from Election Commission, but there were 3 different answers that were received from the same question. What are your views on that? And if something like that happens, how can one deal with that issue?
So 3 RTI filed by 3 different persons.
That hasn't been written in his question, sir, but he just
Okay.
says that there are 3.
No, I think that has been filed by 3 different persons, because one person is not supposed to file repeated application on the same matter. Okay, it is not allowed. Okay, so presume that it has been filed by 3 different persons. Now see, if for 3 different persons, if 3 different answer is given by the same public officer, you need to check whether the response is given by the same public officer or not. Okay, that is not clear to us. So if it is given by the same information officer, then it is a mischievous act. Okay, it is a mischievous act, it is a misleading act by the same public information officer. You can file an appeal, first appeal, or you can also file complaint as well. Okay, but if the 3 act together, then you can make your case stronger. Okay, so what I understood, that for single query there should not be 3 different answers. Okay, so if for a single query, same public information officer given 3 different answers to 3 different RTI applicant, it is a misleading one, and he is supposed to be penalized under section 20, that is imposition of fine and through initiation of disciplinary action. Okay, and second is, you need to understand on which I am also thinking to conduct an research, that always the public information officer don't respond as per their own wish. Okay, because they are always the junior level officer, so sometimes they respond under the pressure of the higher authority. Got the point? Like PM Cares Fund, if I refer that example, do you think that a public information officer can respond to an application relating to PM Cares Fund without consulting the PM, without consulting the secretary of PM? The answer is no. So as a junior officer, they sometimes remain under some burden. They also sometimes under pressure respond in such a way. Okay, and you know what will happen? Either imposition of fine 25,000, it can be easily given because they are drawing huge amount of salary. And if the disciplinary action is ordered, then they will simply warn them that don't give the answer in such way, and the case will be managed. So that is why these things are happening. Okay, because under the RT Act, exemplary punishment is not there. That is the problem. Okay, and government by itself encourage the violation of the RT Act. Okay, so for that there is a movement needed to increase the punishment under the RT Act for the information officer as well as for the public authority.
Thank you, sir. So, a final question, which is quite generic. It's by Pooja Agarwal, who asks whether a law aspirant should go for litigation or judiciary, or in other field, how a person should decide, and how can one improve the person's drafting skills, because it's easy to theoretically learn, but practically doing it in courts is very difficult.
Okay, now she is having two part in his question, in her question, isn't it? What line she should choose,
Field and
and
how to improve.
how to develop drafting skill, isn't it?
Yes, sir.
So to respond to the first part, it is that, see, I will always encourage, okay, make your passion as a profession. If you like litigation, go for litigation. If you like job, go for job. Choose judiciary, other law related job. If you love, excuse me, if you love corporate lifestyle, you go for corporate sector. If you love teaching, you go for LLM, qualify NET, do PhD, join teaching service. Okay, so make your passion a profession. So here you should not take any advice from somebody which line you should choose. What advice you can choose or you can take is that what are the positive and negatives of that particular line. So what is the positive for practice, what is the negative for practice, what is positive for teaching, negative for teaching, what is good side for judicial service, what is bad side for judicial service. So you know that everything has its positive side, negative side, and there is a maxim, I hope you have studied, approbate and reprobate. So if you are choosing one side, if you are choosing one thing, and if you are choosing that I only choose it only for its good side, not the bad side, you cannot do. So when you are choosing something, you have to take that thing as a whole. So be familiar with positive and negative side of the line you are choosing, either judiciary, practice, or teaching. Okay, then you make a informed decision. Okay, but to conclude it, I'll say if you are having a family background, then you can think of going uh, go for litigation if you get interested. Okay, if you don't get interested in it, don't go. And second is, for the women, they don't want peaceful life, so you can think about teaching, that is doing LLM, and then you can join teaching service, a peaceful service. Okay, and if you want to bring any social change, then you can be in either of that, in teaching or in practice. Okay, so you have to uh, think, or you have to decide first which area interests you, and then you give me the area, then I can work on it, I can give the advice. So I have no specific answer for that. Okay, so it's about your passion and knowing the positive and negative side of it and deciding on that. Okay, it might be seem as a vague answer, but I think it is the right answer.
Yes, sir. Thank you. So there's just one more question from Gaurav Singh, who
Yes.
asked something little controversial. He asks, what is the action taken when the apex court of the country refuses and reduces the ambit of application under the RTI Act? And then he refers to an example of the former Chief Justice of India, Ranjan Gogoi,
Yes.
whose molestation case was asked through an RTI but was refused by the highest court of this country. And the second question is, how was he in the
No, no, no,
same
no,
panel
no, no.
hearing?
Sorry. What happened to RTA case? RTA?
Uh, so he
Did
says that
no response from Supreme Court.
no response. Yes, sir.
Okay. Then what is second part?
Then the next part is, how was he in the same panel that was hearing the molestation case?
See, I hope all of you are familiar with Visakha guideline. Okay. So thereafter, then in 2013, one special act is passed, isn't it? Protection of women from sexual harassment at workplace, isn't it? So under that act, uh, I am answering the first part, the last part first. Okay, then I will answer the first part later. So uh, when a complaint of sexual harassment is being lodged, okay, in the organized sector, Supreme Court is definitely organized sector. Okay, so the case should go to the internal complaints committee. Case should go to the internal complaints committee. Let me say that Supreme Court itself is not above the law. Everybody is under the law. So this act, that 2013 act, very much applicable to the Supreme Court itself. Okay, that is under the Maternity Benefit Act, creatures has been established in the Supreme Court. So if creatures is established in the Supreme Court, then internal complaints committee should be there. So for my knowledge goes, Indra Jaising written that internal complaint committee is not there, or even if it is there, then it should be, the matter should have been referred to the internal complaints committee. Okay, so there should be internal complaints committee in the Supreme Court, and that case should have been sent to that committee. So it only this, that is lawful. Okay, now second is that the Ranji Gogon cannot sit as a part of that committee. All right, so see, judges are constitutionally empowered to do wrong. Judges are constitutionally empowered to do wrong. So sometimes, you will be familiar with the term impunity. Impunity means some wrong goes unpunished. When wrong goes unpunished, it is known as impunity. So he was so powerful that nobody was there to act against him. Only we can write, we can file case, but we cannot act against him. So even see, only there are numerous renowned advocates. They also did not file any public interest litigation in this matter. Okay, last what happened? That lady was reinstated. That lady was reinstated in her service. That lady was near from this Saharanpur, Uttar Pradesh. That is the one university is there in Meerut. I am forgetting the name. So that lady studied law and that university. Okay, so that lady obviously familiar with the protection of this 2013 Act, but the case was not referred, and the perpetrator is so powerful that nobody was in a position to act against him. Okay, so and another important thing is that the committee headed by I think Ranjan Gogoi was part. I don't think he was head. You correct me if I'm wrong. So the ICC should be headed by a senior woman employee under the this 2013 Act. But everything has happened under the pressure. If justice, okay, so in judiciary the ethics is most important. So that is why Ranjan Gogoi is being criticized even after holding the highest positions in the Supreme Court, isn't it? So that is one thing what has happened. It was not right, and then thing has been managed, by reinstating that employee. And that lady is also not raising any voice nowadays after getting reinstated. Keep in your mind. So that is most surprising. All right. So that is the first point. So case can be managed, and when
So,
you will be in practice. Yes. Yes.
sir, even if she decides to raise a voice, what is the option she has? Because she's tried to get a remedy from the highest court of the country, but if that has disappointed her, then what is the option she has?
See, the thing is that if the internal complaints committee, whatever complaint she has given, okay, if that complaint is not disposed of legally, then she can file a writ petition before the Delhi High Court. Okay, he should not go directly to the Supreme Court because he was the Chief Justice. Now otherwise can be decided because now he is no longer Chief Justice. So she should move the High Court first that her application has not been disposed of according to Protection of Women from Sexual Harassment Act 2013. Okay, so High Court will decide accordingly. If it has not been decided, High Court will ask the Internal Complaints Committee to take up the matter and decides under that act. Okay. Now, under that act, what kind of punishment can be given? Ranjay Gavan is already retired. Some fine can be imposed. Retirement, there could be some cartel in retirement benefit. But again, the questions comes: who will judge the judges? Who will judge the judge? That is, will the High Court judge will be powerful enough to take a decision against the retired Chief Justice? So that is the question. Might be you can find the powerful judge, a judge with integrity, a fearless judge might be there, but lady has to move. But now that lady is not moving. Lady is working in the Supreme Court because it has been compromised, and you better understand what does compromise means. Both side has to sacrifice something. So that lady has sacrificed his dignity, but gain her service. Okay, and Ranjay Gagon has reinstated her, given her. That is whatever decision he has taken by removing that lady. So he suffered loss, that he was compelled to change his decision, but he has gained. What is the gain? That he escaped the punishment. What the point? But remedy is still available. But if the lady is not interested, so how it can happen? Cannot happen. If any public interest litigator can raise the issue, then also it can happen because it is a case of crime. But nobody is, what should I say, that nobody is courageous enough to take up the issue before the Delhi High Court or Supreme Court. Okay, so this is the last part, and first part should I answer? That is the RTA matter.
Yes, sir.
Okay, so one RTA has been filed in this respect, but that has not been responded. Okay, but thereafter what action the RTA applicant has taken, that is not known to me. Okay, so if the Supreme Court is not responding or not responded to the RTA application, in the Supreme Court, you will find the first appellate authority. You have to apply before the first appellate authority with a first appeal. If the first appeal is dismissed, then you can approach the Central Information Commission. Then the Central Information Commission will decide. Okay, so you have to follow the process. Otherwise, you cannot expect remedy. Yeah. Yes.
Yes, sir. Interns, because of paucity of time, we will have to end this session. Thank you, sir, for that elaborate and patient response. And thank you,
Yes,
interns, for joining us. On the message chat box, there's a feedback form that has been given. I request all interns to fill that before you leave. Okay, kindly fill that and leave the meeting. Thank you, sir. Thank you, everyone, for joining us.
Okay. Thank you. Thank you, Mali.
Thank you.